Welcome. This is the first video blog from the Law Office of Justin Sweeney. I'm going to briefly be discussing the new DAPA and DACA laws and how you can get a green card from them. It should be noted that a judge in Texas stalled the entire process, and we are currently awaiting the appeal from the government to hopefully finalize the implementation of these new laws that President Obama passed back on November 20th of last year. However, we're still waiting. I have the most frequent question I'm getting right now in my office is in regards to people that not just qualify for this new application, but also what they can do with it. It's very important to understand that the new DAPA laws, just like the current DACA laws, the Deferred Action laws, only allow you to get a work permit. It's not a visa of any kind. It's not a permanent resident card. It's obviously not citizenship. With these work permits, you can get driver's license. You can take out a social security number. There's a lot of things you can do. You can sleep well at night knowing that you are now legal in the country, but you can't travel with them. They're not. It's not a green card. You can't vote with them, things like that. So, but there are other opportunities out there for a lot of people, and a lot of people just don't know about them. One of the most common scenarios and fact patterns is people that already have deferred action through the child program have U.S. citizen boyfriends or girlfriends or spouses. And if that is the case, if you are currently under DACA protection, you have a work permit, and you have a U.S. citizen spouse or a boyfriend or girlfriend that you're contemplating getting married to, it is possible to get your green card through them. And this is how you do it. So assuming that you have the valid work permit, we can apply for what's called advanced parole. The easiest way to explain this is it's like a visa to leave. Everyone else is trying to get visas to come into the country. We're going to request a visa for you to leave the country. But you will know 100% for sure that when you leave, you can come back. Okay, it's a piece of paper that you'll have, and you can leave during certain dates, and then you'll come back into the country legally. Once you have a lawful entry into the United States, in most cases, with a U.S. citizen spouse, you can then file for your green card under 245A of the INA, of the law. There's a law that says if you have a lawful entry and a U.S. citizen spouse or child over the age of 21, you can file for your green card directly. Very common fact pattern. I deal with it almost every day, and a lot of people don't know about it. But there is a way to get a green card. Even though you can't get a green card right now through the DACA programs or through the DAPA programs, they are not in and of themselves paths to residency or citizenship. There are kind of like little loopholes that we can use to get one. Now, the only way we can get a visa to go to Mexico or your home country is if there is an emergency down there. The most common is an emergency for humanitarian reasons. A sick grandma, grandpa, mom and dad, someone down there that would need help. You can also use professional or scholastic reasons as well. But you should come talk to me if you seem to fit that fact pattern. Come talk to me and we'll see if you would qualify for the visa. And if you do, you would likely qualify for the green card as well. The DAPA program for the parents, again, it has not gone into effect, but the DAPA program, what I'm seeing a frequent fact pattern will be once this law goes into effect is get a work permit for them. Most of these people will have kids that are born in the United States that are either over 21 or close to 21. And so the same fact pattern also helps them get a green card. They would simply need to file for their work permit under DAPA, then file for the visa to leave and come back. And when they come back, their child who's over the age of 21 can file for a green card for them. Many people think that just because you have a U.S. citizen child that's over the age of 21, you can automatically qualify for a green card, and that's not true. While the child over the age of 21 does allow you to file for a I-130, a petition, the only way you can also file your green card application is if you qualify under certain laws. The most common is called 245I, which is if you have an old petition from someone else that was approved on or before April 30th of 2001. If you don't, or you weren't the derivative beneficiary on a petition, you have to qualify under 245A of the law, which requires a lawful entry. Most people have entered it illegally. And if that's the case, we can use DAPA to get the legal entry that you would need to file for your green card here in the United States. This avoids going to Ciudad Juarez, and it usually will avoid doing waivers as well, unless there's crimes at issue. But if I can do that for my clients, I would prefer that 10 times out of 10, 100 times out of 100. File for your green card here. It's more processes and a little more paperwork, but it's easier work. It's cheaper. You get to stay here. You don't have to go to Ciudad Juarez, and you don't have to win a waiver. So it's a win-win for everybody. A lot of it will depend on this new DAPA law going into effect, but people that currently have DACA, the deferred action, already need to know that they have potential chances to get a green card as well. If you have questions, you can call my office, 559-440-6067. Consults are always free. Just mention that you saw this commercial. Thanks.